The European Union's General Data Protection Regulation comes into force on 25th of May 2018. What does your organisation need to do to comply with the new law? In this session, we discuss the obligations and duties of data controllers and processors in the event of a personal data breach. What is a personal data breach? GDPR Article 4.12 defines a personal data breach as a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data transmitted, stored, or otherwise processed. Breaking that definition down into its component parts, a personal data breach could be a confidentiality breach, an availability breach, or an integrity breach. Examples of personal breaches can include access by an unauthorized third party, deliberate or accidental action or inaction by a controller or processor, sending personal data to an incorrect recipient, computing devices containing personal data being lost or stolen, the alteration of personal data without permission, or the loss of availability of personal data. When a personal data breach has occurred, you must establish the likelihood and severity of the resulting risk to data subjects' rights and freedoms. If it is likely that there will be a risk, you must notify the Information Commissioner's Office, the ICO. Reporting is not required if you conclude that there is unlikely to be a risk. However, if you decide that you do not need to report a breach, then you must be able to justify your decision, so keep a record of the reasons for that decision. A personal data breach can affect data subjects' rights and freedoms in a very wide range of ways, from identity theft and fraud to reputational damage, loss of confidentiality, or non-material damage such as personal distress. Consequently, it will often be advisable to err on the side of caution and to report the breach to the ICO. Where notification is required, a breach must be reported to the ICO without undue delay and no later than 72 hours after becoming aware of it. Guidance issued in October 2017 by the European Union's Article 29 Working Party indicates that the 72-hour period begins to run when the controller becomes aware with a reasonable degree of certainty that a breach has occurred. If notification occurs more than 72 hours after becoming aware, the controller must be prepared and able to explain the delay. Meeting the 72-hour reporting obligation could prove challenging for data controllers. The Article 29 Working Party has taken the view that as soon as a service provider, that is the data processor, is aware of a breach, that knowledge will be imputed to the data controller. That conclusion creates some tension between the available guidance and the precise wording of the GDPR. The GDPR requires a processor to notify the controller of all personal data breaches without undue delay. One result of the Article 29 Working Party's guidance is that the relevant provisions in data processing contracts may well require the processor to report a personal data breach to the controller immediately, rather than using the GDPR wording without undue delay. What must be reported? When reporting a data breach, you must provide a description of the nature of the personal data breach, including, where possible, the categories and approximate number of individuals concerned. the categories and approximate number of personal data records concerned, the name and contact details of your data protection officer, if you have one, or some other point of contact, a description of the likely consequences of the personal data breach, and a description of the measures taken to deal with the breach, including, where appropriate, any measures to mitigate any adverse effects. It may well be that all of that information is not to hand when you first make your report to the ICO. Where that is the case, the ICO is prepared to accept phased or staged notification as details become available. If a breach is likely to result in a high risk to the rights and freedoms of individuals, you must inform them directly and without undue delay. Individual notification might be required, for example, where confidential medical records are disclosed, as the sensitivity of the data could mean that disclosure would have a significant impact on the affected individuals. If individuals are to be notified, you must tell them in clear and plain language the nature of the personal data breach, and, at least, the name and contact details of your data protection officer, if you have one, or other contact point, a description of the likely consequences of the breach, and a description of the measures taken or proposed to be taken to deal with the breach and mitigate its effects. As well as GDPR, organisations operating in particular sectors need to be aware of any special rules that apply to them. Examples include communications service providers, such as telecommunication operators, who must notify the ICO of a personal data breach within 24 hours to comply with the Privacy of Electronic Communications Regulations, or PECR, PECR. PECR is due to be replaced by a new EU e-privacy regulation, but the implementation date for that new regulation has yet to be finally confirmed. UK trust service providers are also subject to a 24-hour reporting obligation under the Electronic Identification and Trust Services Regulation, or EIDAS. A key feature of GDPR is the significantly increased level of administrative fines, potentially reaching up to 4% of global annual turnover, or 20 million euros, whichever is the higher. However, fines are a remedy of last resort, and in many cases the regulator is likely to make use of its toolkit of enforcement powers, ranging from information notices to undertakings, audits, and administrative orders, such as stop-now orders, requiring organisations to take or to refrain from taking particular steps after a personal data breach. Even with the best will and with genuine efforts to comply, it is always possible that a personal data breach will occur. What can you do to mitigate your risk and to increase the chance of the regulator exercising its discretion to impose something less than the most severe penalties under GDPR? Preparation and rehearsal for breach response can make all the difference. Ensure that you have appropriate policies and procedures in place. Put in place and test a breach response plan, mapping out roles and responsibilities to ensure all key personnel know what to do. Carry out mock breach exercises, and keep your IT and organisational measures under review, including encryption of vulnerable data. If you have any queries or would like to seek advice on any of the issues discussed in this session, please contact our data law team. Contact details are on your screen at the moment. Thank you for listening to this GDPR webcast. Please join us for our other sessions on data controllers, data processors, data protection officers, data privacy impact assessments, and contractual issues for GDPR.